Welcome back to Talk Studio. I'm Nancy Mae Skinner, an attorney with Fager, Amsler, Keller, and Schoppmann, and I'm here for a special Halloween episode of Talk Studio. We're going to talk about a scary practice called anchoring and the verdicts that have resulted from anchoring that will truly horrify you. So anchoring is a technique used by plaintiffs' attorneys where they request a specific sum in their closing argument or summation. So the summation is the last thing that happens before the jury is instructed on the law by the court and they go in to deliberate. So the plaintiff's attorney will say, in my opinion, the pain and suffering for this plaintiff in the past was X dollars, and an appropriate award for future damages would be Y. So when those figures are so wildly excessive that they're not comparable to any awards that have been sustained by any court in the state of New York, that's anchoring. So it'll be, I think we should award $30 million in pain and suffering awards, or $50 or $80 million awards. And then the jury goes back into the jury room with that being the only figure they've heard, and an understanding that that is a reasonable compensation for the pain and suffering in the case, when it's not, and when it's not something that will be sustained on appeal, but it is something that will result in a wildly excessive jury verdict. There are two statutes that come into play in this anchoring issue, and the first one is CPLR 4016B. This case, or this statute, permits a plaintiff's attorney to request a specific amount, a dollar amount, during their summation for any category of damages, most likely pain and suffering, because it's the most subjective award that's typically made. And then CPLR 5501C is a provision that says when an award made by a jury deviates materially from reasonable compensation, then it will be reduced by an appellate court or a trial court, or a new trial ordered on that aspect of the case, the damages aspect of the case. So what defendants have argued, thus far unsuccessfully, is that these two statutes should be read together, that the amount that's requested pursuant to CPLR 4016 should not be an amount that exceeds what is reasonable compensation, as has been determined by the courts up to that point. So take an example. If you're evaluating how much would be reasonable for a fractured ankle, you look at other cases where courts have valued a fractured ankle, where juries have made awards and appellate courts and trial courts have said whether they're inadequate or excessive or reasonable. And then you look at plaintiffs that are similar to the plaintiff who you're evaluating. So is it in a similar part of the state? Awards tend to be a little higher downstate than upstate. Is it a plaintiff who's a similar age, and is it a similar injury? And if it is, then you can have an idea that that's a sustainable value for that particular injury. So what the defendants assert would be reasonable here is that if there are going to be made, or an anchoring demand is going to be made during the plaintiff's summation, that it be limited in some fashion to a reasonable amount. I'm going to talk about a few cases today where anchoring has been successfully used to result in excessive awards that have had to be reduced on post-trial motions and appeals, and still have created a whole new ceiling for what is a sustainable award in the state of New York. The first case we're going to discuss is Hedges versus Planned Security and Target, among others. And it involved a plaintiff who was injured when some teens threw a shopping cart over the top of a shopping center balcony, and it landed on the plaintiff, causing organic brain damage, incontinence, and cognitive and physical injuries. The case went to trial, and during the plaintiff's summation, an anchoring demand of $8 million for past pain and suffering was made, and for $50 million for future pain and suffering. So for a total of $58 million in pain and suffering, something that's not even close to a number that has been sustained previously in the state of New York. The jury returned a verdict awarding $16 million in past pain and suffering and $29 million in future pain and suffering. The defendants moved post-trial to the trial court asking that the awards be reduced because they were wildly excessive, and they were reduced to $3 million past pain and suffering and $14.5 million future pain and suffering. Still, $17.5 million is a figure that has not been sustained previously in the state and was, multiple times higher than anything that had been sustained in the state of New York. So an appeal was taken to the Appellate Division First Department, really the last word for this case on value. And the appeal was on two grounds. One was that the anchoring practice should be limited or precluded. And the second one was that this was, the verdict was excessive. The appellate division declined to address the anchoring issue. And it's because it hadn't been raised below in part. So that's something that we're going to talk about how we can fight this going forward. And the appellate division did make a further reduction, not in the past pain and suffering, that remained at $3 million, but the future pain and suffering award was reduced to $10 million. So for a total award of about $13 million in pain and suffering alone. The second case is Perez v. Live Nation, and that was also decided by the First Department in this calendar year. In that case, the plaintiff fell from a height while working on a stage set at Jones Beach and sustained a traumatic brain injury, had seizures, was permanently disabled, another substantial injury case. And during the case went to trial, and during the plaintiff's summation, an anchoring demand was made of $35 million for past pain and suffering and $50 million for future pain and suffering. So for an $85 million award for pain and suffering alone. Again, something that has never been sustained in the state of New York. And I think everyone knew going into this trial that that would never be sustained. But again, it set that expectation for the jury that that was somehow a reasonable number. And then the jury came back with a verdict of $10.5 million past pain and suffering and $75 million for future pain and suffering. So we had an $85 million award. The defense made a motion post-trial to the trial court to reduce the award, and it was reduced to $30.1 million future, and the $10.5 million past award was sustained or remained. So it went up on appeal to the First Department, both on the issue of the excessiveness of that award and the anchoring issue. Just to backtrack for a moment, the trial court had addressed the anchoring issue by saying, I'm not going to decide this case. The trial judge said, I'm not going to decide the issue of whether anchoring is appropriate because I think that's an appropriate issue for the appellate courts or for the legislature. So now it goes up on appeal. The appellate court reduces it to $5 million past pain and suffering, $15 million future pain and suffering. So a $20 million award for pain and suffering. When previous to that, the ceiling or sort of the high watermark in the state for brain injury cases had been about $10 million. So it's just about doubled what was the new high watermark. And the appellate division said, we decline to address the issue of anchoring. So again, the appellate courts were not willing to address or limit the use of the anchoring technique. The third and final case I'm going to talk to you about today is a medical malpractice case, a verdict that was awarded in a case called Reddish. The plaintiff in this case had a particularly severe type of asthma, and she came to the hospital so sick that she needed to immediately go to the ICU, was placed in an induced coma and treated. And when she came out of the coma, it was determined that she had sustained a brain injury as a result of the high CO2 levels. The case went to trial, and the plaintiff's attorney, in summation, made an anchoring demand of $40 million. The jury responded with a jury verdict of $90 million for pain and suffering alone, again, wildly excessive. And on post-trial motion, the trial court reduced it to $30 million. The case went up on appeal, and on the two issues, again, the limitation or preclusion of anchoring and the excessive award. During oral argument of the appeal, the panel of judges who were hearing the case seemed headed down the Perez-Hedges road. They were talking about value for this case and talking about the values in Perez and Hedges, which we now now know was a $20 million ceiling. And the hospital's attorney made what seemed like an argument that really resounded with the court, saying medical malpractice cases are different. You have hospitals that are facing all kinds of economic challenges, and if they're socked with, outrageous awards, they're going to go bankrupt. Physicians carry $2.3 million in coverage typically, so they don't have the coverage to withstand a $20 million verdict. So the court seemed sympathetic to that, to understand that distinction, and when they awarded $10 million, still double what would have been expected before Perez and Hedges came along. It was a little bit better, let's say, than the $20 million that we saw in Perez. So it's a strategy that we may want to use moving forward, may want to reference moving forward. And so what else can we do? Well, MLMIC is working with their healthcare partners on the legislative side, addressing this issue in the legislature and also with the courts. With the courts, we've joined in amicus briefs or friend of the court briefs on each of these three cases, trying to provide a broader perspective to the court. So an amicus brief doesn't argue the same way that a party argues their own case. When a party goes up on appeal, they talk about, what has happened in that particular case and how, the impact that it has on the parties to that action. An amicus brief says, take a broader look, court, on how your decision in this particular case will impact people across the state, the statewide implications. So the medical society, for example, may file an amicus brief talking about how a particular decision could impact all medical providers across the state of New York. Or a specialty society, say ACOG, could file an amicus brief that would talk about how the decision in that particular case would impact OBGYNs across the state. There's all different kinds of amicus briefs. In the cases that we spoke about, it was a broad-based amicus brief from a variety of different professions and businesses that joined in the amicus brief just to address excessive verdicts generally and their impact on defendants generally in the state of New York, including the influence of anchoring. So, encouraging any societies that you're a member of to join in these amicus briefs is very helpful. And then the last thing that we're doing at MLMIC is really getting the word out, because this is, while anchoring's been around for a long time, it's really accelerated. The use of it we're seeing it more, and the impact is more significant. So not every case will result in an appeal because the issue is not preserved. So at the time that an anchoring demand is made for a wildly excessive amount, at the time of summation, the attorney needs to object to it to move for a mistrial, and that sets the stage for that appeal. So we're making sure to get the word out. Make sure you're objecting. Make sure you're making that motion for a mistrial so that your appellate rights are preserved. That's where we are today. We're keeping an eye out on anchoring. If you have any questions about anchoring, please feel free to reach out to any of the attorneys at Fager, Amsler, Keller, and Schoppmann, and we'll certainly keep you advised. Thanks for tuning in to Talk Studio, and have a happy Halloween.